Clear love. Right. Good morning. It is January 16th in Senate Judiciary. We have the state's attorneys and sheriff's office here for a general update. And I do first just want to note that we don't have a quorum at the moment, which is my understanding. It's procedurally okay. We can still, Senator Norris and I can still be here to receive this update. I think we'll have some other members trickling in here over the next 5 to 10 minutes. Yeah, the floor is yours.
Thank you so much for having us in. Tim Leaders, Dumont, Executive Director of the Department of State's Attorneys and Sheriffs. We have that effect on the quorum as an issue. And also, I think joining us on screen is, maybe she'll be joining us soon, is Kim McManus, who's our legislative attorney to appear remotely. And also in the room, 2 members of the department. We have Sheriff Anderson from Windham County. And we also have our new Director of Labor Relations and Operations, Lauren Clemens here from our central office. So one of the things I was going to briefly do is I gave you reading material over the weekend, posted on your website is this presentation, which is a snapshot of the year end for 2025 judicial filings. We've done, for the last 3 years, we've done a snapshot of judicial filings in May and December. And the December one is pretty interesting from our perspective because it's a wrap up on where things stand right at the end of the year. And it also captures what is pending coming into the legislative session. So I always find it to be pretty helpful for legislators to sort of hear about the filings, because it really drives our entire operations. Everything from transport deputies and what they're doing to our deputy state's attorneys, our administrative professionals, our big advocates, our state's attorneys. And of course, the filings also drive what's happening in our court system. And so on your website, you can dig into that. I was going to point out just a couple of things. Trials, the main driver of case resolution. The last 2 years, over the last 2 years, we've had an 107% clearance rate, 104% clearance rate. Since 2022, we've had 107% clearance rate. I would like to continue to see that elevate up to more like 150%. We still have about 22,000 pending cases in our system, of which 19,000 are criminal cases. The others are family, juvenile, that sort of.
Senator Bones.
I know we have a backlog. I'm not disputing that. But I also imagine that we always have some number of pending cases. And prior to the backlog getting to this point where it was really detrimental, do you have a sense of what sort of the average number of pending cases per year was?
So I'm talking about filings, because what I have is actually the number of cases pending regardless of year of file. But we file between 12 to 13,000 cases a year in the criminal system. And that has been pretty consistent for a while. What changed during not just COVID, even before COVID, was how quickly we were able to resolve them. And as I was saying it was potentially appropriations yesterday, we file more misdemeanors than felonies, but we have many more felony trials than we have misdemeanors. So the opportunities for trial resolution continue to be stacked on the felony side. So it's inverse to the number of filings that we have. And so one of the things that's on your website as well is, as of December 24th, kind of a snapshot of the accountability docket pilot that we talked about in both government operations and appropriations already this year. But in my opinion, a really great opportunity to see how we can do court differently. And as of yesterday, we cleared 500 cases of this 890 that we originally started with, relating to about 100 defendants. So that is a one way to sort of think about misdemeanors or nonviolent felonies going through the system.
Well, I follow up because I actually wasn't asking about filings, although that is helpful information. What I'm trying to understand is, prior to the backlog really exploding in any given year, how many pending cases are sort of sitting? Right now, we're saying it's about 22,000. I'm trying to understand how much larger that is than what we would sort of typically expect.
A healthy system. And so in 2023, we had 26,000 pending cases. So we moved thousands of cases since 2023. We could do a query of like a 2018 or 2019 pending list. Odyssey has happened since that time in between. So I would want to check with the judiciary staff on that, but I will get back to you on what a 2018 or 2019 case pending list looks like. What we do as well is we don't just talk about criminal, because we do the CHINS filings and the juvenile and the YO and PCRs and civil division. So we try to do a full picture for our department, but just getting to some sort of contextual pieces. And then Kim, has Kim joined us yet?
Yes.
Yeah. Kim McManus will go over our legislative priorities, which I know is really the core of what I think you want to hear from us today. But the contextual piece concerning data, right? We still have about 45% of our cases relate to people with 3 or more pending cases. It's a big driver of court activity. We also have 2023, we had 90 pending homicides at this point. 2024, we had 96 pending homicides. And at this point, we have 111 pending homicides. So over a 3-year window, we've seen about a 24% increase in homicide filings. That's different than the date of incident. Someone could have had a homicide incident in 2021 and it's investigated, doesn't get filed in 2023. But just in terms of filings, that's a major pressure on our court system. And then we have on the opposite end, those repeat defendants. They're competing for the same court. So contextually, accountability dockets, what I think should be really the focus of our judiciary. How do we balance major felony time in courts with misdemeanor or nonviolent felony time in courts? Because they both groups have victims and defendants that deserve speedy justice. And we have seen great success in the Chittenden pilot. And so we hope that some of the learning that we've seen through that connection to AHS, connection to services, and repeat scheduling and flexible scheduling within short windows of time by the judge can help move more cases. In our opinion, we think we should be having more space and more time for the nonviolent and misdemeanor cases so they can have speedier justice. Recently, we've seen that in Chittenden County, state's attorney was able to clear every firearm related incident where there was homicide involved in 2022. 2022 was a high watermark of homicide filings in state history. I believe there was 27 homicide events that year. There was more filings in part because of the residual date of incident. But we've moved those and now we're dealing with our 2023 or 2024, 25 homicides. But that shows you it takes 3 to 4 years to get out of once a homicide's been filed to dispose of that homicide. And those are our most often some of our most time-sensitive cases. So I'll let you dig through the data on your own. You have 2 data sets on your website. One is the judicial filing data for the year. One thing I will point you to, and when I come in front of appropriations next, I hope to have a big blow up. But if you look on further down the line, I created a map this year. Someone said I should create a map. So I forget exactly what page it's on, but right in the middle, talking about caseloads, just give you a brief snapshot of that. So we have 300 cases on average assigned to a SAS prosecutor. We have about 600 cases assigned to each of our victim advocates. And administrative professionals are a little bit different because in some offices, they touch every case, and in other offices, they might split up by alphabet or misdemeanor, felony, et cetera. But I did my best. We have about 800 cases, 790 something cases per administrative professional. We have a group of prosecutors that have 28 prosecutors that have 300 or more cases on average, and they hold 411 cases on average each. On the map, you'll see there as well, number of pending cases and then homicides as well. I thought those were important pieces because even in a county that has maybe a lower caseload, they might have a fair number of homicides. And that's puts pressure on a county, on the courts, et cetera.
When you say a fair number, I assume that's sort of relative. How many homicides happen in Vermont in 2025? I know the filings are different because sometimes it takes a while, but I'm wondering how many homicides actually happen.
In the back of this, you'll see the 2025 data because it just ended. They settle, and there's some things where they don't know if it's like they're still being qualified as a homicide yet. So we have to wait until the 2025 data settles. At the back of your presentation, there's NIMBR's reported incidents through 2024. That data has been analyzed. We have to wait on the incidents and DPS and BCIC, et cetera. And Vic could talk more about the 2025 incidents, but I don't have the 2025 incident number for homicides yet. But we do have the numbers from 2017 to 2024, which are in the back of your presentation. What we have only at this point for 2025 is 35 homicide filings this year in our courts for pending cases that were filed in 2025. An example of the Bennington case that we just resolved from the 80s, we filed it in 2025, right? So the incident happened many years ago, what we filed this year, and it shows up in this year's filing. And we resolved that case almost as soon as we filed.
So filed this year, does that mean it happened this year?
Yeah.
Okay.
Yep.
And does that filing number include attempts or only?
It includes attempts, conspiracy, aiding and abetting. It includes the full spectrum of attempted, yes, we would say attempted murder. The way we do it is a literal search of the terms murder, manslaughter. All the homicide filings fall under those categories. And so we do include aiding and abetting, accessory, after the fact, attempt, that sort of thing. And one of the things we've seen is, and Kim McManus can speak to this at some point, she did an analog look at some of our affidavits for the past couple of years, increasing nexus to firearms, and in those affidavits, increasing mentions of drug-related activity. And so that those two pieces, right, and it'll get into some of our priorities for the year on firearms, for example, we've seen that nexus has increased and put pressure on our system. The domestic violence homicides are a very important data point in terms of the increase in homicide filings. The increase we've seen has been more drug-related and firearm-related violence. So I will, with your permission, Mr. Chair, if there's any other questions, I will be right here, but I will hand it off to Kim McManus on the priorities whenever you want. But I see it.
Yeah, no, I haven't had a chance to look at that yet, and I certainly will. And I'm wondering, sorry to really harp on the homicide. I just want to make sure I really have a clear understanding of what happened in 2025, what was an attempt, and so I'm wondering if it's broken out in that much detail. Awesome.
We can, the way it's the court gives us the files in an Excel sheet. So what I'll have to do is pull the homicides and then break out the cells to see what the actual charges are. But we could get that to you. It'll be a longer document. And we might have to de-identify some of it if it's now like a juvenile case or something like that. But we can get you the more granular data on homicides, but it does include that full spectrum one of the things it doesn't include, which is a huge pressure on our department, and I'm looking at Sheriff Anderson because I know it's impacted his office at times, the unsolved cases that are in the midst of investigation where we're doing search warrants, we're doing geofence warrants, we're doing forensic work, DNA work. Prominent cases remained unsolved in Rutland, a homicide that took place during the day on like that. Castleton, it's an unsolved case. Doesn't mean that there's not a mountain of work happening behind the scenes with state's attorney's office and with law enforcement. So those are the things beneath the surface that don't show up in a filing unless you search through search warrants and things like that, which are an important, voluminous part of what we do as well, assisting law enforcement with search warrants. Feel free to dig into the data, and at some point I could come back and do a more granular, but I wanted to make sure you had it on your website. It's the December 10th annual snapshot that we do. You also have the accountability docket data, which breaks out sentence types since October 20th. And I know we could spend an hour on that, but I'll hand it off to Kim on any priorities and our agenda for the session.
I just have one question about the filing breakdowns. When I look at that breakdown, can I also see in the filings what actually happened in 2025 and what was filed in 2025, but maybe happened in a previous year?
On the filing data itself, just the judicial filings, it won't show the incident date. However, and it sometimes in investigations, incident date will, like, for example, each law enforcement agency has an incident coding system. Not all of them, and I'm looking to the chair as well, like VSP has a particular incident coding system for incident numbers. It often aligns with a year, but it's not always, it's the year of the investigation. It's not always the year of the commencement of the act that took place. But you would have to dig into the affidavits for the 2025 filings to see, sometimes it's this investigation started in 2022, and after the following steps, we have now filed this homicide case. But we can dig into that and see if there's a way to analog, pull that out of there. Technology we have today, maybe there's a way to load in those affidavits into some sort of system and pull out dates or something like that. We can look into that.
I appreciate that. I just really want a complete picture when we think about what happened in 2025 versus what was filed, because there can be such an incredible lag.
There's a lag, yes, absolutely. And again, at the back of this presentation, there's 2017 to 2024 data across a whole bunch of areas based on the NIPERS data. But that's all in there for you. And you will see a lot of Kim McManus, as I know you already have. And so she's really, this year has been a really important part bringing together, and I'm really happy to share our positions here. Our state's attorneys and our sheriffs have agreed on a unified agenda, which is really wonderful for me because it means that I can represent 28, or the best of my ability, roughly 28 offices. And there's always some distinctions, as Senator Norris knows, between the different county offices. But with that, Kim, I'll hand it off to you.
Thank you, Tim. Good morning, everyone. I apologize I could not be there today in person. We have a little situation at home I need to deal with in about 35 minutes. So I will keep my remarks short for you all. As Tim Tim alluded to some of our priorities already, given the data that he was running through. And if you have looked at our priorities outline, I'm actually going to run through it in reverse. So if you're following along, just so that I don't lose you, I'm going to start at point 10. We have 10 priorities for this session. And the first one, as Tim mentioned, was the backlog. And I know that's important to this committee, as we were just discussing the backlog in relation to the speedy trial bill just the other day. As Tim said, we are committed to looking at legislative and administrative solutions to this backlog, and we would highly encourage the committee to dig into the accountability docket data that Tim has presented, and again, maybe create some space and time for us to talk specifically about the success we're seeing there. An important update that I just heard on Tuesday is that as of Tuesday, January 13th, 509 dockets have been closed out of the I believe it was 803 that the group started with. And the prosecutor also conveyed that there are 4 or 5 plea agreements that are already organized and ready to go, and that'll be finished by the end of the month. So we, again, want to press upon this body that when we create this dedicated space for these misdemeanor cases, these cases get resolved. And so if we can collectively keep thinking about how we can make this happen, again, either legislatively and or administratively, we will be supporting those efforts. Our next priority, and one that's already started to get discussion in House Judiciary, is fixing the definition of recidivism. And this goes to just better data across the board. Currently, the definition in our statutes for recidivism is tied to an incarceration period of a year. That is the starting point. So then if you reoffend, you're reincarcerated, actually. That counts towards our recidivism definition, which is definitely not how we, among stakeholders, are discussing recidivism as far as somebody reoffending after having contact with our justice system. This was raised last year. We had brief testimony on it in the House. It has already been brought up in the House in Bill H410. I know there's a similar Senate bill. It looks like we are going to greatly edit the current 410 and bring you a much simpler bill, but just starting with redefining recidivism and potentially just changing the name that currently is collecting that reincarceration data. That data is important. We just don't think it should be called recidivism. So we think there's some simple fixes there to work our way towards better data. Our next priority is the expansion of the hearsay exception, which is H5. That has gotten days of testimony right now over in House Judiciary. So we're looking forward to that hopefully being discussed and voted out relatively soon. What that would look like for you all is you are likely aware that Rule of Evidence 804A, allows children 12 and under, allows that if they've made a disclosure prior to a legal proceeding, that those disclosures can come in as a hearsay exception during a trial for an abuse to a child, generally sexual assault, but also any serious bodily injury to a child. H5 seeks to expand that to add 13, 14, and 15-year-olds. and our department supports that expansion. Next in our priority list, and this has actually been voted out of the House and will be coming to you soon, hopefully, is there was an issue that was raised last year when we were discussing bail revocation. And the issue was essentially that the legislature did not want to define certain terms that the judiciary should be defining through case law. And that's a simplified explanation. When we were discussing it, we realized that the way the bail revocation statute is currently written and the appeals that are attached to any appeals around bail, it was actually unclear whether the prosecutors could appeal the decision when a judge denies a motion to revoke. So we've asked for clarifying language on that. The House passed H409 just last week, the committee voted it out. And so it'll be working its way through the House. And we hope that you will consider that and give prosecutors the ability to appeal those revocations, largely so that we can get more case law on this. We need to know where the limits are for when we can ask for these revocations and when we cannot. And it's a little unclear right now. Any questions so far? I apologize. Moving quickly.
Nope, not that I'm seeing.
Okay. Our next priority, which is it's always a priority, but this year specifically, when we look at centering victims in our justice system, we would like to again review midpoint review for probation and discuss the efficacy of it, whether or not it's actually working the way the legislature intended it for it to work. And if you wish to continue with the concept of midpoint review, we would strongly encourage that a conviction for a violation of an abuse prevention order not be included in the exception list, that should not be an offense. That should be eligible for midpoint review. Next in our priorities, we have about a 5-page DUI drug enforcement recommendation, which has currently been encapsulated in H637. As many of you are likely aware, we are seeing more and more drug cases for our driving impairment cases, either that they are exclusively drug or alcohol and drug combined. We're seeing less and less alcohol specific driving under the influence cases. And with that, we need some updates in our DUI law to make sure we are appropriately being able to enforce and prosecute drivers who are driving under the influence with drugs in their system. I will admit this is a complicated area that we will bring in our traffic safety prosecutor to discuss. So if you have any questions on the specific areas around that, we definitely need to set aside very specific time for that. And I would bring Dennis in to walk you through on our suggestions. All right, moving along, we are seeing more and more cases involving firearms in our state, as Tim alluded to. And Senator Vahovsky, I know I owe you an email. I've been trying to clean up what I want to send you so that it makes the most sense. But as Tim mentioned, I took a look at all of our 2025 filings for anything homicide related. So homicides, attempted homicides, conspiracy related to homicide. And what jumped out, and this is the 2025 filings, is that of the, and I apologize, I have too many screens up right now, but again, Senator Vahovsky, I will give you the very specific numbers, but there were, when I did the poll, if there were 27 filings, 3 of them would be considered domestic violence, And of those, only one was intimate partner violence, and all of the others had a either gun and or drug and gun related incident around it. So either somebody owing somebody money for drugs, or a gun being used in some tangential way, that there was a drug offense, and or the other remaining ones had a mental health component to it. So we are seeing more and more gun-related homicides not tied to intimate partner violence. And we have a few firearm pieces of legislation that we are supporting. The first one is you are aware that there is the prohibited persons. If you have certain convictions, felonies, and/or DV-related convictions, or you have certain pending charges, you are prohibited from possessing a firearm. We would like that prohibition to be expanded to persons who have been found in need of treatment under Title 18 and/or have had a hospitalization order or non-hospitalization order issued. We would like that expansion to take place. We would also like to make the theft of a firearm felony. Currently, any theft of a firearm, the charging decision is based on the value of the firearm. We would like to move that away from the value and just the essence of what it is, the firearm, making that a felony. We've also are aware that there are some other firearm pieces of legislation coming out from the House that we haven't fully dug into, but we will do that. But we are aware of those two pieces, and we support those as a department. Moving on, along with the increase in firearms, we are seeing an increase in organized crime in our state, and we believe that Vermont would benefit from having its own RICO statute so that we can get to the heads of these criminal organizations and not just picking off the bottom. We believe that these criminal organizations are using our most vulnerable people in the state and are getting away with profiteering off Vermonters. And we would like to have our own RICO statute so that we could go after the heads of those organizations. As this group is aware, there is a gap in our system between our mental health system and our criminal justice system. Excuse me. I apologize for my voice this morning. We strongly believe that the state of Vermont needs a forensic facility that would aid defendants who have been found incompetent and help them restore competency so that they can see through their trial and have a end to that process. We also believe that we require a facility that if somebody has been found guilty but insane, and they are still posing a substantial risk to the public, that we need a secure facility for those persons. There are a number of bills, one on the Senate side and a few on the House side, that are looking into this area. I know it's a conversation that has been discussed for many years, but we do believe that this is the time for this body to seriously discuss these issues and see what we can create here in Vermont. We suggest that we start with our most serious offenses, those who have been accused with an offense that could have a life offense as the consequence. That is the smallest group, but the ones who pose the most risk to our community, and that would be a good place for us to start to have these conversations about the benefit of such a facility.
Senator Rohowski, and then I also have a clarifying question.
It's possible that this is a better question for legislative counsel who's not in the room, but because you are, I'm going to ask, could you remind me what the offenses in Vermont are that carry a potential life sentence?
Yes, and Tim, feel free to help me out if I don't have the exact list in front of me, but our homicide cases, so first degree, second degree murder, sexual assault has a life offense max, kidnapping, that might be it.
There may be a couple other more obscure ones that are less charged, for example, terror, in the terror statute, that may have one, but we could give you the full list with the life offense punishment.
It's
I'm sure legislative counsel can as well. I just add we're talking
Those are the
about
big
it.
ones.
That's very,
it's a relatively small list, and yes, happy to give you an exhaustive list.
thank you.
Kim, my question, so I feel like I want to say maybe 3 years ago, we passed a forensic facility bill, and I must be misremembering or forgetting something. I mean, what I thought happened was that some beds were added to the Berlin facility. Did that? It made like literally just a couple of beds, I think. But so is the suggestion now that we have to expand that and like build a whole new hospital? Is that what the suggestion is?
So the suggestion from our department would be that this forensic facility be under the Department of Corrections. And we have been informed that there is potentially, I believe, a wing in the Southern State facility that could be potentially used for this. In other conversations with folks recently, I was told that DMH potentially has a facility that could be secured, but I do not know enough information about that. But our suggestion is that this actually be under DOC with a medical provider inside the facility instead of under DMH trying to create a secured facility. And by starting with only life offenses, we project that looking back the last few years, the number of individuals who would qualify would be about 4 to 5 at any given time. So we do not contemplate needing to build a facility.
Okay.
If DOC could, in fact, refit this space down in Southern State.
Got it. That's helpful. So it's more of revisiting what the rules are for who can be placed in one of these facilities, but also authorizing DOC to potentially turn one of the wings at Southern State into this facility.
I say yes with the qualifier of that I'm not sure of the legislation that you referenced from 3 years ago. My understanding is that there is no current forensic facility. There's no space where we are doing competency restoration.
Well, and if I might just jump in 1 second.
Sorry. Yep.
Oh yeah, with some of the
I was
history.
just going to say, oh, sorry.
Yeah.
Go ahead.
Go for it. Go for it.
I apologize. This is for folks who do not have a hospitalization order. So folks who have a hospitalization order, I believe, Senator, and again, I don't have the language from 3 years ago. I believe that's the beds that you're likely thinking of. If DMH has a hospitalization order and can hold somebody, these are for individuals who DMH deems are not eligible for a hospitalization order, but who still pose a substantial risk for the community and are either incompetent or insane and have been found guilty.
I was going to mention the hospitalization piece because I think one of the important, and Kim and I are obviously in the same context, because one of the important pieces that we're seeing is that the gap is when there is no hospitalization order, or when we even see many cases where there's no ONH, an order of non-hospitalization. So the true gap is where someone and where there's victims in the community or the public is concerned, but where there's been a violent offense, where a life offense is the potential punishment, and the individual is deemed not fit for, and there's a technical term which I will leave AHS and the administration to fill in the gaps on those, but where they're not going to be hospitalized and the ONH, and maybe they don't get an ONH, that's the true gap. But even for some of the ONH pieces, there's concern. And for example, if an individual is accused of killing their family member, and this is just something we've seen play out, and the judge says that the individual will not be hospitalized, and perhaps the best option is an ONH, that is also a gap, right? That the person's going to be returned potentially to the same home on an ONH. That's another gap. But that's actually not even we're talking for the most part. We're talking about people that are truly in the gap of in the in between, and they have. And then there's a great example during World War II, an individual who was engaged in propaganda with German access. An American was engaged in espionage, catastrophic levels, and was deemed incompetent. And 50 years later, they were found competent and prosecuted. The liability with respect to, that's not even a death case, so to speak, if it had the effect, the liability related to these cases never goes away for life offense. And so that's why I think we believe the life offenses is a really important conversation, because they could be found competent 20 years, 30 years after the offense, and then they're right back into it. So if they're going to have that liability hang over their head for the rest of their life, we do think Vermont needs a space for them to be able to defend themselves as well, restoring their competency, understanding the court system. And as we all remember, just as a basis from that testimony 3 years ago, competency is fluid. So if you commit an offense on a Monday and you're found incompetent, you commit an offense on a Tuesday, you're presumed competent again. Insanity is what can be deemed at trial as a defense. Competency is whether or not you can engage with the system at all. And that's the two different pieces there. And so we do think that this conversation is important, and we've been very appreciative of having this ongoing conversation, particularly with the governor's office, about how do we start with this? Because I just looked at the number of pending cases where there's a mental health element in terms of our system, and all of the dockets in the system. This may shock some people. These are cases where the individual's inactive, so they've probably been found potentially incompetent, or there's a mental health piece that's pending. So an inactive case is still a pending case. 1.69% of all the dockets. 332 total dockets relating to 47 people. But it shows you that those 47 people may have very serious cases attached to them. And you all hear about it. We all hear about it. The victims are very engaged on these issues as well. So we're trying to fill that gap without overshooting the mark, I think. That's our attempt, I think. Sorry, Kim. Yep.
No, that was wonderful. Thank you. And as some of you may be aware, just want to highlight that this is not our department's event, but we will be there listening on Wednesday, January 21st. Kelly Carroll from Vermont Voices for Vermont Victims is holding a public hearing at the State House at 2 p.m. And there'll be, she has 4 other individuals who will be speaking with her. They are all victims who have been involved in cases where the case has not been able to go forward because the defendant was incompetent and or that the defendant has been found guilty but insane. And I think those stories will be very powerful and interesting to this body. So we would encourage you to attend or to listen. Lastly, last session, there was a tremendous amount of discussion about our juvenile justice proceedings, particularly, or specifically, I should say, around our older delinquents, our 18-year-old delinquents, and our YO proceedings, and concerns about whether or not we are able to hold these older, it gets very confusing, the child or youth. So I'm going to say youth, though that's not the right definition legally, but for these younger adults who are in our family division, holding them accountable and actually being able to provide them the services that they need continues to be a struggle. And we want to continue that conversation this year with you. There's a few specific things we would like to move some of the delinquencies that are eligible for 18 plus over to YO. DCF has they repeatedly said last year they are not well equipped to handle 18 and over probationers, so to speak. They do not have the ability to make them do anything. If the delinquent does not wish to engage in the services, there's no consequence that the DCF can provide. And with YO, we at least have the combination of DOC and DCF, which provides a bit more accountability. So we would like to have an ongoing conversation with you about what offenses, and we are looking particularly at aggravated domestic assault, aggravated stalking, certain sexual assault charges that are not currently in the Big 14 that we think would be more appropriate as YO cases, not as delinquency cases. We also want to discuss when a youthful offender is not engaging at all and is not showing up for court, how we can move that case back to the criminal division. Currently, if a youthful offender does not show for it, even if they've reached the point of a revocation of their youthful offender status, if they don't show for that hearing, the revocation cannot happen currently. And we think that is something that we can address relatively easily with due process for the youth, but we need to find a mechanism to bring them back in and have them re-engage with us and potentially go to criminal court if they are not able to show that they can engage with the youthful offender status. Lastly, and very importantly, we are having different decisions from judges about whether victims can be heard at the consideration hearing. When we are deciding whether a case should go into youthful offender status or the youthful offender tract, there is a consideration hearing. We believe that the law currently states that the victim has the right to be heard at that hearing. We have some decisions coming out of various courts denying the victim's ability to represent their thoughts and feelings about how this case should be handled. And we would like to clarify the language in 33 VSA 5288 on that to make sure that victims are heard and considered. Any questions?
I'm not seeing any.
The full list is on your website.
Great. Yeah, thank you, Senator Norris.
I do, it's not necessarily a question, Tim. Well, in speaking with other stakeholders in the 3B project, what I'm hearing is, and you've testified, that this appears to be a very successful adventure that we've entered into here. And I'm sure there's going to be some interest from other counties to also do this, but I don't think what I'm hearing is one of the reasons that it is successful in Chittenden County is because of the resources that are available within Chittenden County. I'm not sure that all of the counties have those same resources. So two, what would be, you don't have to answer this today, but what I'm interested in, what would be the potential cost drivers on this for the state's attorneys and sheriffs? And if it won't work county to county, I wonder if anyone has entertained this for a regional approach toward this. Is your opinion on having another witness company?
Yeah, no, and I will actually send you a bit of a thought piece, if it's okay, Mr. Chair and Mr. Vice Chair, on what that looks like, with the key element of replication is not going to be a copy and paste of Chittenden, like you said. And I think, yes, regional or another approach should be floating. So Right now, we have a unified treatment court judge, travels the whole state for treatment court. Senator from Government Operations, myself, were talking about this the other day. And there was some pushback initially, and I actually engaged in some of that pushback. But Judge Griffin has done a really excellent job of thinking through the consistency of dropping into counties. And we could take a similar approach with maybe a couple floating judges and maybe even a couple floating, I would say, service-related folks. The key elements that we've seen: flexible court time and space. Keep hearing that. And the second piece is access to services right there in the courtroom, or right out at the courtroom. It would be no shock to you all in this committee that people often who are engaged in this behavior struggle after they see the judge to go connect with services, if that means they have to set up an appointment or even walk down the street. When I was in Washington County, I was quickly alerted to the fact that it was difficult to get from the courthouse on Main Street to the diversion office, also on Main Street, maybe 200 feet away, 300 feet away. And people would not connect with diversions. So having that gap right there closed in the courtroom is going to be key. If you're looking at a place in the Route 7 corridor in and around Chittenden County, there could be some great synergies, taking that same stuff we learned from Chittenden, popping it up to Franklin, down to Addison. Rutland has an interest in the counties. I'm just going to say on the record here that I really think you should consider now. Rutland, Wyndham, Franklin, are some of the ones that come to mind to me, and Washington County as well, with lots of cases coming in, lots of volume, some access to services where we can pick up. Key element, we were talking about transports earlier. Access to a facility close by has really helped with the Chittenden program, particularly for the Chittenden facility for women. And the male facility up in Franklin's not terribly far away. So a Rutland with Marble Valley right there would be a fantastic place to see how this plays out. Wyndham has it, Springfield's not terribly far away. Washington is in a bit of an interesting desert with no facility. You got to go to St. Jay or Springfield or Chittenden or Franklin. And so even though it's a high volume location, you'd have to sort out how the transports would flow. And I will lastly put on the record, because Sheriff Anderson and I have talked about this at great length. Right now we have 21 filled positions for the transport deputies. We have 25 FTEs, but there's about 600 detainees and there's 7,000 felons. The math does not work out to have 21 people transport that number of people if you're going to have an explosion of accountability dockets. So everyone's going to have to pick up the slack, all law enforcement agencies, and DOC and the rest of the people that are able to transport, to make it work in some of those other counties. And I think we should always exercise existing resources first, exhaust those resources, and then move on. But I'm happy to give you my thoughts on what it looks like. And the last piece, internally for state's attorneys, admins and victim advocates, turning around court filings and notices to victims. When you have court hearings every week, as opposed to 30, 60, 90 days, those requirements speed up quicker and quicker. And so whether it's overtime dollars or whether it's boosting our admin, paralegal, and victim advocate staff, which is cheaper than our deputy state's attorney staff, that could help get stuff out quicker for the accountability documents. But it's a great question. I'd love to come back on this.
I imagine more ability to transport people would not just help within the accountability, it would help across the board with the backlog. Do you have a sense of what a healthy number of transport deputies would be?
Yes. I mean,
are you allowed to tell me what that number is?
I'm squirming here. No, I will say this. Last year we asked for 6. We got 1 unfunded, and deeply appreciate this committee's support for that. A fund position, Senator Norris and appropriations has been deeply helpful in that. But we've also struggled because our overtime budget has been cannibalizing the rest of our budget. So to hire for those positions, we probably need to boost up our overtime dollars, because the courts are the ones that set our schedules. And when we have a hearing at 8 a.m., someone's got to leave at 4 sometimes, or 5. But I would say for both the major felonies where people are detained, we need more transports to get into the court. And for accountability, someone's held on $200 bail, let's get them into court quickly. It's both ends of the spectrum, just like our court time. I would say right now we have 25. I would love it if our department had 30 transport deputies with maybe a floater that we could send. Urgent accountability case coming up, we got to send them out. That would be healthy, I think. Wouldn't be 40 would be great, but 30 is a number I think that our department has really settled on as not being insufficient at this point.
So you may or may not have done the math on this, and perhaps my logic is off, but logically I would imagine if you had an adequate number of transport deputies, there would be less overtime, and thus overall would cost the system less.
if we can get the judges to engage in block scheduling between 10 and 2, that will cut back on our overtime. Also better for the defendants to have certainty of when their hearing is going to be. So yes, plus better scheduling from the judges. Yes, and yep.
Okay.
Yep. And we're working on that. 7 of our counties, including Wyndham County, are now engaged in conversations, and they're going to do it in Wyndham County. So Sheriff Anderson could sit in here in maybe a month or so and say how that some of that's going in.
And I would also imagine that clearing of these dockets would decrease spending in all kinds of places because we'd have less people detained. We'd have less.
Yes.
Okay.
No,
So-
actually, you'd see other parts of the state budget would be alleviated of some of the pressures, for sure. Yeah.
So an investment in 5 more transport deputies is a cost savings investment.
With a healthy, until we get the scheduling sorted, with a healthy overtime budget as well, I would say. Yep, both. Yep. Thank you so much. Thank you very much for having me in.
Thank you. Since you're here, did either of you folks want to testify or just come to have me?
Mr. Chair, I'm happy to answer any questions, but I was not coming to provide testimony today. But since some things were brought up, I'm happy to at least mention things briefly.
Yeah, just wanted to see if you were, if you wanted to be sitting.
Well, you've got the sheriff here, you can put it
Yeah,
in the
chair
chair
as well, especially the sheriff. County.
Well, thank you, Mr. Chair, members of the Community Judiciary. So the record, my name is Mark Anderson. I'm the Sheriff of Wyndham County. Ditto. So we started block scheduling in Wyndham County, working with the court administrator's office, specifically with the court clerk, court operations managers, and the judges to set up a more efficient schedule. This was actually not a new process. We had it running in Wyndham County in 2018, 2019. And so there were some things that did cause a shift, but at the end of the day, with the partnership, with the cooperation, with the understanding of the bar, and the judges, we have started on January 1st, formed as the second, the block scheduling in Wyndham County. So we're delivering prisoners from 10 o'clock till 3 o'clock, and at 3 o'clock we head north. We're doing this as a method to manage our overtime right now. But again, it's something that we used to do, so it should not be too much of a upset. And it also means that attorneys can meet with their clients, have enough time for like a 1 o'clock hearing. What we frequently ran into is we would be scheduled for an 8 o'clock hearing, and then the hearing wouldn't actually happen until 1 o'clock. So my deputies are waking up at 2, 3 in the morning to pick the person up, to have them at the court at 8 in the morning, to not have anything happen until 1 in the afternoon. Then they have to go back to wherever they came from. Another issue, again, we've been working with Department of Corrections on this, but it all has to do with efficiency. We are told the day before the person is at Southern State Correctional Facility. That's a 30-mile drive for my team one way, so 60 miles round trip. We get to Southern State Correctional Facility for the 8 o'clock hearing to find out that they were moved to Northeast Correctional Facility, and now we're driving to Newport. So we've just added 2 hours onto the trip, if not more, in just one direction. So these are all just pieces that we work through conversation to make things more efficient and to reduce overtime. Speaking for myself, I would like to see the Department of State Attorneys and Sheriffs have 56 transport deputies. So, I mean, everybody comes and says, we want this, we need this, whatever. Where I'm saying that's because we're operating on a regional correctional system. In my county, I have the Brownwood Retreat that deals with not only the private patients, but also with state patients in the Department of Mental Health's custody. My county uniquely handles that. In Chittenden County, there is the Chittenden Correctional Facility, which handles female populations. Chittenden County specifically deals with that and supporting other counties in the state. So as we look at the regional system, we start finding counties that are supporting a regional need. That's a statewide solution. And so it sometimes falls on the sheriff's head to support this, and then not having any control of the overtime because we have no control of the schedule. It turns into a problem we're trying to solve for reasons before the legislature. So the block scheduling, in summary, does a really good job of allowing us to manage what's in our control with cooperation and understanding of the other partners. But it's always an opportunity for education and identifying new ways.
Well, thank you very much. Good to see you. And we do have Chris Brickell.
So I've been an advocate of block schedule for years, obviously, and work further down too. I'm not going to tell anybody. Who runs roughshod over? Is it the individual judges or is it Judge zoning that will instruct? Who has that final determination?
Fundamentally, it's a relationship between the court operations manager and the judge over the docket, who are supervised by Judge Zone. And so formally it's the judge of the docket. We worked with Judge Keenan and Judge Treadwell and Judge Barrett to say these are the issues and these are very real issues. If we do not solve our overtime problem, we will not have transport deputies to do this because we don't have the funding to support it. And then they said, we understand and we work with them. At the end of the day is the local docket, and they've been incredibly supportive and appreciative of our ability to work with them as well. It's not a hard and fast rule. We said we understand there will be exceptions, and it's a two-way street. So this is by no means us just demanding our way, and no other considerations be had. And also, just briefly, we'll note that the block scheduling applies to like what I'll call the standard issue hearings that the court has. It's not dealing with things around trials, jury draws, suppression hearings, and I believe there's one other hearing that I'm
Like a Rule 24, someone who invokes their 24-hour rule, that's not something, it's the defendant's right to wait. And so that's something we can't control either.
So we are certainly working with all the things that exist as understood, but as a general practice, it's that 10 to 3 in my county, and it's going well so far. 2 weeks in here. Thank you.
Thank you. Appreciate it. It's always good to see you.
Likewise. Thank you.
For the game.
Brickell
Meeting with Judge Zone about.
Maybe I could pull you in.
Good morning, Director Brickell. Thank you very much for all your flexibility. I appreciate it.
Thanks.
My understanding, our committee did have some questions, I believe, regarding the Criminal Justice Training Council as it relates to 208. And as even noted in some correspondence, it does include licensure, which falls in your realm a bit. So just wanted to give you the opportunity to share any thoughts that you may have, and also provide the committee an opportunity for any follow-up questions regarding the bill.
Absolutely, Chair, and thanks for the opportunity. For the record, my name is Christopher Brickell, Executive Director of the Vermont Criminal Justice Council, also with the Police Academy. I'll be brief because this bill S208 really impacts the council in one significant way. And it's really at the very end of the bill on page 3, line 18, under the penalties section, which proposes a monetary fine of not more than $1,000 or a loss of the officer's professional licensure or certification. That becomes problematic for us simply because, as I know that you're well aware, the council is the body that provides issues certifications to all law enforcement officers that grants them their authority. We do not regulate or certify federal law enforcement officers, so that's the first problematic piece. And we also have no authority to sanction them. And so in this process, there is what we have already by statute outlined how we sanction law enforcement officers for any violations of their certifications. They're broken down essentially into 3 categories of Category A, which is around criminal conduct, Category C, which is really around the council processes, and then the one that this would normally fall under would be a Category B, which is defined as a willful failure to comply with a state required policy or the law enforcement officer's code of conduct. Those are sanctions that would be possible if this bill moved to be created as a policy rather than a bill. There's a couple of other issues that I see in here as far as challenges, but they don't directly impact the council. So I think it's probably in the best interest of your time if I am here to address what questions you might have around the certification piece or anything else related to the bill.
Yeah, I think, and this is just my own perspective on this. The more I've thought about it after doing some research, my suggestion is going to be entirely removing the officer losing their professional licensure certification, if applicable. And I know that as it's written, it wouldn't apply to federal officers. However, as it's written, it could also be construed in such a way that would, in my opinion, weaken a defense if/when the state were to be sued as a result of the legislation. So I guess my follow-up question to that is, if the penalty were only a $1,000 civil fine, essentially a traffic ticket, is that something that would prompt the Justice Council to initiate any sort of investigation or misconduct? Misconduct investigation.
It would not, Senator. It would not have any impact if this was solely changed to a civil violation. I do see a handful of other concerns or problems with that process, but it would not impact the council at all.
And I heard yesterday that the council is developing its own rules around the topics discussed in this bill. Is that right?
The council is not specifically around this. The council does have a seat on the LEAB, the Law Enforcement Advisory Board. I've heard some suggestion that there might be a potential for the advisory board to take that up. And if so, I know that there was a discussion at our meeting last Monday where there was positive feedback that should this come to LEAB's way, that they would more than willing to take it up.
Thank you. Do you have questions?
I don't know if it's a question so much as, well, maybe it is a question. So I'm going to preface it with a concern. And my concern is that I actually think this type of behavior should be able to be considered as misconduct. And so I'm wondering from you, what would trigger that type of investigation? Because I assume law enforcement officers are not supposed to break the law.
That's correct. But if this is not a law that penalizes a criminal offense with it, then that would take it out of the category A realm conduct. And this category A conduct is very strictly defined already in statute by what offenses it does cover. The category B conduct does cover a willful violation of a statewide policy. So if there was a statewide policy and it identified the behaviors that were not desirable of Vermont's law enforcement officers, and there was a willful violation of that, that would come directly to the council.
Okay, but in order to be under category A, it needs to be a criminal offense, not a civil offense.
That's correct.
Okay. Thank you.
Great, that is helpful. And I know you mentioned you had a few other concerns. There were also a few other pieces that I wanted to get some better language on. But yeah, be happy to hear your concerns first.
Well, my concerns were just around the piece that I heard about it becoming a potential civil violation, which would then be, heard in traffic court essentially. And those folks that issue civil offenses are law enforcement officers. So, essentially what you would be setting up a process to have happen is if this was a civil violation, you would be having officers issue civil violations to other officers for a violation of that. That seems problematic. There's a large amount of, and rightfully so, discretion issued to officers who see violations on whether or not the sanction should be a civil violation, whether a warning is appropriate. I don't know that there would be a way to outline a mandatory enforcement mechanism if this was a civil violation. You would also be pitting law enforcement against law enforcement, essentially. And I think that would be problematic.
Any other thoughts or concerns that you wanted to outline?
As far as thoughts, I do believe that I honestly understand the intent. And I think that I'd like to say, based on what I see for violations that come before the Council on Law Enforcement Officer Conduct, that Vermont law enforcement officers take all the things that are ongoing in today's climate very seriously. And I do know that I believe Senator Vyhofsky was one who witnessed or identified an issue with a Vermont law enforcement officer that was wearing a mask and called it out, and it was appropriately dealt with. That's not a normal practice. But having said that, I do think that if this were to go to the LEAB, that's something that would be taken seriously as to what the intent of the law was, and that I think Vermont law enforcement understands that masking themselves or not being able to identify themselves is not the way that they hold their relationships with the communities that they serve.
I appreciate that, and I hear where you're coming from, and I understand what you're saying. I think what's put out there is, generally speaking, I don't think that it is really part of the ethos that I've seen in these local and state and deputy office law enforcement to engage in, generally engaging in anonymous masked law enforcement. I don't think that is a regular occurrence in Vermont. But as you mentioned, you did highlight the general intent and what is happening around the country as well. And yeah, just my own general comment. I do see Senator Vyhofsky with her hand up.
I do. So I have a couple of things. I think that, with the status quo, we're kind of asking individual LEAs to develop policies or to deal with it, which seems like a piecemeal way to do it. I'm wondering, with some changes, I think we're all aware that some changes in this bill need to be made. It would be feasible and possible to pass this law and have the LEAB develop a statewide policy, correct?
Yeah, absolutely. I mean, if the legislature wanted to as well push it to the LEAB could, in addition to statute, create a policy that did impact all of Vermont law enforcement officers. Yes.
And what do you think the time frame is for that? What's the quickest that the LEAB could do that?
My guess from prior participation is, I would say, 6 to 7 months for conversation, drafting, and then once that policy was in draft form, that process would then be clearly it would be reviewed by the Department of Public Safety, the Commissioner of Public Safety, and then it would be provided to the council for the council to review that draft and then vote to accept that as a statewide policy.
Awesome, thank you. I appreciate that. One of the things that sort of come to mind for me that I think having a law like this creates, in addition to transparency, accountability, and in enhancing public trust, if we have a law that says law enforcement should not be doing this, if someone is doing this, the public has a reasonable sort of space to be like, that might not be a good actor, right? Like, because one of the concerns in addition to police doing this is people who are not police doing this, posing as police, to act poorly. And so as I look at this, it protects police and the public by saying this is not behavior police should be engaged with.
I think yes, in a way it codifies the behavior that you already see from Vermont law enforcement, that they don't do things that hide their identities, with the certain exceptions and carve outs that I think everyone could understand that would be reasonable. That said, yes, I think that, you could accomplish both of those tasks, whether by law and or by policy.
Thank you.
Any other questions? Okay, great. Thank you, Director. Appreciate your testimony today.
You're welcome. Thanks for the time.
Yeah, have a good weekend.
You too.
So regarding this bill committee, do you have any thoughts, concerns, other witnesses that you want to hear from? I think we have it for markup on is it Tuesday, Wednesday of next week. We got it for markup at some point next week. Tuesday, thank you.
I'll start. I don't like the bill it's written. Okay, and I think we all know the intent of the bill. We can say whatever we want. We want, if we want to have the LEAB come up with a policy for Vermont law enforcement, I can support that. It doesn't happen rarely in the state of Vermont. But I think the underlying current here, we're not targeting Vermont law enforcement, they're targeting federal. And I don't think that should be, in our particular area, should be doing just that. If we can support Vermont law enforcement, if we want to control that, that's fine, but I don't like the it's written reference to. And we know that even if they have a policy, we have to put it in statute with both the federal and local, because California's going through that right now as far as discrimination. Federal supremacy. Because they're claiming that they're being discriminated against because they didn't all of them. So we know what's going to happen here if it happens. So I don't like the bill written.
Got it. So just to clarify, this does cover all law enforcement. It doesn't focus specifically on federal law enforcement.
I know that.
Okay. Maybe I misunderstood what you said.
No, I said I agree with the policy through the
Yeah.
LEAD for Vermont law enforcement. That probably can still happen, but we're still going to have a state statute that says all law enforcement versus, and I think that we're overstepping our boundaries. My personal opinion.
Yeah, so I've heard some compelling testimony that there's some language changes that need to happen, and particularly in some of the exceptions. And I recognize that at this point, in many spaces, we're sort of in uncharted waters, but the testimony from the constitutional law professor was fairly compelling to me that this is defensible. And I feel pretty strongly that it should apply to all law enforcement operating in Vermont. I do, however, support including that perhaps a more extensive policy by the LEAB or more fine-tuned guidance might make sense in addition to the law on the books. The other reason I feel like having the law on the books would be good is I just feel like, given everything that's happening in the fear within our communities, that 6 to 7 months for some type of response is too long. But I do feel pretty strongly that any law enforcement in Vermont should operate under these procedures. And, the constitutional law professor gave me a fair amount of comfort that it is defensible, that we're not targeting federal law enforcement. We are saying this is what Vermont expects of all law enforcement.
No pressure.
No, I'm just trying to think about how I want to word it, because Commissioner Morrison came in and said, with all the exemptions that are out there, and I brought it up to what's a weather emergency, cold weather emergency, things like that. And with those exemptions and how it works with the LEAB and the Criminal Justice Council as it pertains to Vermont law enforcement. And I really do have bigger concerns about what the state can do with federal agents. And I have more questions on, when you have to identify yourself. And I know there's videos out there, but we don't know when the videos were started. Did the officer say it right before and say it after? I know there's when it's safe to do so, Does that mean when somebody's in the car, they can then identify themselves? I have no idea. So there's a lot of gray area to me in how it would pertain to the federal agencies. And like Commissioner Morrison said yesterday, having that talk already with LEAB for state law enforcement is a great start. It sounds like they're gonna go down that road. Timing wise, yes, we don't always get what we want as fast as we want, but I want to make sure we get it right. I really don't like doing something for the sake of doing something and then a year later coming back and trying to fix it. So would love to see what the markup is. I know we're gonna add probably some edits to that next week, like we said, so.
Yeah, so those are all great points. Mainly to the issue of whether we can or can't do this. My own perspective, I'm fully comfortable and confident with the rights that are provided to us under the 10th Amendment, and with the testimony that we've heard so far about our ability to exercise our sovereignty and govern how police operate internally within the state. So for me, in my own opinion, that's not an issue at all for me. I do agree with you on the rewording for some of this. It's like the cold weather exception. A number of these are at this point sort of placeholders to cover the general topic. There are plenty of instances where, like looking for a lost hiker or looking for a lost hunter, and it's negative 10 degrees and it's not a weather emergency. You have to wear a mask so you don't get frostbite. But then also there's on the other hand, it's the phrase, you don't want the exception to swallow the rules. So it's, you're going to make this long list of exceptions and then make it essentially a non-existent rule because of all the exceptions. So that's one of the things that I think we're going to have to hash out. And one more point. Can't remember what it is, but did I see your hand up?
Yes, but my infection is another.
Sounds good. I think that really is everything right now. Generally speaking, is there anything folks want to talk about, discuss?
What are we doing for 209, the location one?
Yeah, that one is still a bit further behind. We still got some testimony. I think we have some testimony scheduled for next week. Okay. We're gonna have some markup and discussion on that one. There's still more work to do on that one, I believe. Right, I know. And personally, I would like to add churches and places of worship to it. That's my own opinion. Yeah, that's where we're at on that one. It's a bit further behind the two away.
I agree with adding churches and places of worship, and I know that there's probably some testimony coming in surrounding some of the definitions and potential some other additions. I did want to just let you know that Tennessee has a bill introduced that does include churches. So there is, it hasn't passed, but it is introduced. There is some other conversation in other places about churches, so it's not totally unprecedented.
And I think the other piece was also, remembering 209 is getting a definition of schools.
We're going to have to define it.
I believe there is a definition in the 2200 series, pretty sure. And I can ask St. James. And then also further defining what a community-based shelter is.
What's a worship? How's that defined?
Right.
Churches and indoor places of worship.
Yeah, that's the.
For a lot of people.
Yeah.
How broad is that?
Yeah, there's it has to do with. I can't remember the full definition, but sincerely held spiritual or religious beliefs is one of the elements for what is place of worship. There's some case law out there. I just don't have it just off the top of my head. I think though that we can get more information on that. But yeah, it's something that we'd have to hash out and make sure to actually have a enforceable definition.
When you have a copy of the 2200 series definition, I'd love to take a look at it because I'm making an assumption as to what it probably includes, and I'm not entirely sure that it is going to include everything I intended to include.
Okay.
Because I actually would like these students or to cover child care.
Guys, congratulations. Thank you. Coming to have it. Go back next year. Go.
Going back to general conversation. Nominees, we're gonna be getting some witness testimony Thursday and Friday of next week. And the nominees will have the opportunity to respond that day or a later date if they want. And if there are any witnesses and you folks hear about, let Emery and myself know and we'll try to get them on the schedule. I've repeated multiple times, what the guidelines are for witnesses. I won't repeat it again, but yeah, so got anybody?
I actually have a question about this and it's sort of tricky. So I have had people who have reached out to me, who want to speak, but are afraid of retaliation should the judges make it to the Supreme Court. I'm wondering if there's any way for people to submit anonymous testimony or because I've had a bunch of people who've reached out and it's just this conundrum that they're in. They're like, yeah, I want to say something, but here's all my concerns and why I feel like I can't.
Yeah, I mean, no to the question of anonymous testimony. I've been grappling with that myself, being with the fact that it's a awkward position, overseeing this because there's a reasonable possibility that in a number of years or whatever, I could be in front of the nominees in the Supreme Court arguing a case in my outside of the legislature in my professional life. So I mean, I think this isn't legal advice, but I do think there are maybe later. I think that the possibility of requesting a specific Supreme Court justice be recused from a certain argument is a possibility if somebody wants to testify. I don't know. That's my initial thought, but the answer to the question of anonymous testimony is no.
Okay.
Regardless of whether it's positive or negative.
Okay. Yeah, I have heard that concern from multiple people, so I wanted to put that.
Yeah, so I get that concern, but it's we haven't allowed anonymous testimony, and I'm not planning to allow it. All right. Well, if that's all, I think we can adjourn early and everybody.